Mr. Susu had been 3 crossings, the easiest pumpkin center, the hardest bar X. I'll let you take it up.
Yes, and it's due to the nature of the terrain at these crossings. The river is much wider at the pumpkin center, so the water has more room to distribute. And the bar X crossing, to my understanding, has much more dangerous terrain. There's a lot of holes, there's a lot of drops, and it's more narrower, so the water is going to be much stronger at that location. And for the defendants to essentially say, well, we really didn't know this could happen, we had no idea, you heard what Lacey Rawlings said in there, that they were visiting Daniel's father. And I have to assume this wasn't the first time that they were there. In fact, I think she admitted that they, of course, they'd been there before. So they were definitely familiar with that area, with that river, and with those crossings. So I think that when they take the position that they didn't know this could happen, it's not supported by the facts. And this statement by Lacey Rawlings, nothing in this statement has been challenged or contested during this entire case. So I could assume that we could go to this for accepted and uncontested facts because it came directly from the defendant herself. A few other important facts that I will mix into my argument later on, Judge, is that on 3 separate occasions, we have children who are having fun trying to instigate adults who are supposed to be acting like adults and exercising proper care and supervision over children being talked into doing this by children. We have Lacey acknowledging that they even had a discussion before deciding to proceed into the water. That Daniel said to her, "Do you care?" And she says, "I don't care. The children are having fun." And I think that is the most important fact in this entire case, and I'll demonstrate why. Next on the PowerPoint, first we have a fairly distant photo of the barricade and the warning sign at that location that Daniel Rawlings decided to disregard, to drive around, ignore.
And so that's bar X.
Correct. But that's the actual barricade that he drove around, yes. Next frame. We have a little more close-up. As you can see, the barricade is right in the middle of the road closed. That is put up by county roads when they deem the water to be too dangerous for people to enter. There's a stationary sign in the background, yellow, "Do not enter when flooded." That sign is always there. There's another clear close-up right on the side of the road. So that is the barricade, and that he drove around, and that is the sign that he chose to disregard and ignore. Next shot, Paul. And this is a photograph taken the next day. This kind of gives you a little bit of an idea of the enormity of the water in that river. We can see a couple of rescue personnel on the water's edge, and the water is up to the chest on one of them. Next frame. Here we have a close-up of one of the rescuers. This is at the edge, the water's edge, and he's in chest deep. The next portion is an actual video of the vehicle that was involved in this, that was being removed by county personnel the next day. As you can see, this vehicle is essentially fully submerged in the water. A very large military transport type vehicle, probably 10 to 12 feet in height at the cab, 6 feet just up to the door entrances. Again, this is the next day after conditions had already started to subside. can see how wide that waterway is. The people on the other side, almost like little ants, little insects, they're so far away. Now, as you can see, Judge, there was a large flatbed in the back and then a large cab. And as we heard from Lacey Rawlings, and as was seen by witnesses, both of the defendants and all 7 children were inside the cab of that vehicle. So we're going to look at a couple of pictures that show the location of the seats and the seat belts. Only 3 seats in this vehicle. Those are the 2 front seats. And we know that Daniel and Lacey occupied those 2 seats. And whether they were or not wearing seat belts, who knows? But the point is they took up 2 of the 3 seat belts in that vehicle. Next frame. This is the somewhat deteriorated seat belt from the rear. There's 1 seat in the rear. So there was 1 seat and 1 seat belt for 7 children. We don't know if even one was restrained. And Judge, that is child safety 101. You're riding a vehicle, you have children restrained. And they're not only engaging in this dangerous activity with children in the vehicle, but they're driving all over town out on a highway where the speed limit is 45, and we all know people go much faster than that. They're traveling around to different stores, all the while that these children are unrestrained. That's just for starters. Next, we are going to take a look at video footage that was taken by a witness. And this is a videotape, a cell phone tape of the crossing, the Rawlings crossing at the Pumpkin Center that was referred to by Lacey Rawlings in her statement. Go ahead, Paul.
Yeah.
So what we see in this video, and first we can ask the question, why was anybody even taking this? Well, because it was a spectacle at the time. It was, the Rawlings were drawing attention. They were the only ones that were crossing the creek at that time. You didn't see any other vehicles. So a citizen starts to tape this, and you can see the defendant proceeding very cautiously, even at this safer location. And you can see how wide and vast the water is, and it's running, and there's rapids. And you see him actually stop and open his door and look at the water to kind of survey the situation. Well, what's going on there is it's clear that he's already realizing and recognizing that he is taking a risk by crossing that river. And I think that's very important because it shows that he was already making bad decisions. This led to more bad decisions, and this whole case is about not one bad decision, but a series of bad decisions. I think that's very important for the court.
And Mr. Seuss, was that which crossing? Was that the Pumpkin Center crossing?
Yes, sir.
Not the Bar X? Okay.
Yes.
Thank you.
With that then, before I play the next clip, Judge, I'm going to address Daniel Rawlings' comments that he made to the pre-sentence writer in this case. And as you know, when we get to sentencing, we typically see defendants exhibiting all of this remorse. And in this case, I feel for these people that their children are gone. I feel for what they're having to go through. And I don't have any doubt at all that they're sorry that he lost his children. I wouldn't wish that on anybody. But early on in this case, he wasn't so remorseful, and I think Ms. Jordan's stated in the pre-sentence report that he is profoundly remorseful. And so willing to fully accept responsibility now. But let's take a look at the comments he made in a news interview with Channel 3 News on December 2nd of 2019.
I will say one thing. People go around barricades all the time. I'm not justifying my actions one bit. There could be more done.
Now, those comments made very close in time to this event are quite different than the comments he made to adult probation. After he's had a long time to talk with his attorney about the proper things to say in court. And again, I am not questioning sincerity that he's sorry that his children are gone. What I am arguing is that he is not sincere about his remorse for his actions that caused the death of his children. That he was not so willing to accept responsibility for this just 3 days after it happened. Other people drive around those barricades all the time. That sounds like finger pointing to me. That sounds like someone saying, well, it really wasn't my fault because other people do it all the time. Well, first of all, nobody else was driving around those barricades on November 29th of 2019. He was the only one. So that right off the bat has no relevance to this court's determination. And in fact, there was a subject of a pretrial motion that the court properly ruled that what people may be doing or have done at other points in time, a week, a month, a year earlier, is of no relevance. And then he says, more could have been done. What does he mean by that statement when he says that? Does he mean that the authorities could have put concrete barriers at all the crossings, like they do at airports and sporting events so that people can't drive vehicles in? Is that what he means by more could have been done? Other than closing the roads and putting barricades all over the place and signs. I'm not sure what he means by that. Does he mean that I could have acted more responsibly? Does he mean I should not have listened to children? Does he mean I should have not disregarded those signs? I don't know what he means. Maybe he'll tell you. I'd like to hear what he meant by that. So I think it's important for the court to recognize, again, his willingness to be remorseful for actions that led to this. And I don't think we saw that in that news clip. Now, before I make my closing remarks, Judge, I want to point out something that was raised by defense counsel that I thought was not an issue in the case anymore, because we agreed that it wasn't. And that was defense counsel's reference to rumors that the defendant was consuming alcohol that day. Well, they're not rumors. There's actual evidence that the defendant was consuming alcohol that day. In fact, one of the initial responding deputies, Detective Phil Smith, who was one of the first on scene, detected that the defendant was very vague with his answers and that he observed indicators of impairment, including slurred speech, swaying and unsteady on his feet, repetitious with information that was untrue. Now, Detective Smith forwarded that information to supervisors on scene, but at that time, there was nothing really to indicate other than that there might have been a crime committed. So all of the resources on the scene were being devoted to finding missing children, meaning there was no DUI investigation. There were other witnesses that smelled alcohol from Daniel Rawlings, smelled it on his person, smelled it from the vehicle that he was in, also detected slurred speech, very odd behavior. And I'm not going to get into names and specific statements because I'm trying to be expedient with my time, but I will say that if the defense attempts to refute this evidence, I will be asking for rebuttal this afternoon, and I will grab all of these witness statement folders that I have, and I will go over their names and their detailed statements as to the nature of that evidence. And the nature of that evidence was that the defendant was acting very bizarre, that he was yelling at people, he was yelling at witnesses to go home and mind their own business. He was upset at the rescue, the helicopters, concerned that he might have to foot the bill for rescue efforts. He did not want his children to get emergency treatment, to go to the hospital. These are all verified by witness statements. Now, why did we decide that that evidence wasn't relevant at trial? Because I felt that the evidence was not sufficiently persuasive. There were other witnesses that contradicted that. I'm not sure how to reconcile that, but I just felt that it was not convincing enough to present, and I wasn't even going to mention it today, but since defense counsel saw fit to allude to it, I thought I would briefly address it. Take it for what it's worth, Judge. I certainly don't want you to base your decision on that fact. I just wanted to point out that there is actual evidence to support that, far beyond just rumors. So, everyone in this case, almost everyone, a lot of people, seem to want to treat Daniel and Lacey Rawlings as the victims. Those are the victims right there. Austin, Colby, and Willow. Those are the real victims. The children who suffered a horrible death due to a series of very foolish and irresponsible decisions by the defendants. The 4 surviving children, and you heard from people who are living this, of the tremendous impact that this has had on those 4 surviving children, who will have to endure the nightmares, the counseling, the therapy for the rest of their life. All because the defendants failed to exercise some basic parental common sense. They let a child talk them into driving around that barricade, ignoring those warning signs, disregarding the danger, because the kids were having fun. Now, defense counsel referred in his sentencing memorandum, defense counsel for Daniel Rawlings, in his conclusion that the defendant failed, not because he was goofing off or speeding or drinking. Well, wait a minute. He was not goofing off? I thought we heard Lacey Rawlings tell us that that is exactly what they were doing. Isn't having fun and recreation, isn't that synonymous with goofing off? It certainly is to me. I think most reasonable people would make that conclusion. The judge, sometimes you have to assess the credibility of witnesses. I think that when you hear defense arguments, you should assess the credibility of defense counsel when he tries to make statements like this to mislead you as to the actual facts. The death of those 3 children was completely and wholly avoidable. This is not a tragedy. This is a crime that had tragic consequences, but it is not a tragedy. A tragedy is when a tornado wipes out a community. That's a tragedy. Tragedies cannot be avoided. This was avoidable, easily avoidable. This was not an accident, as defense counsel like to refer to it. An accident is when you're not paying attention, you go through a stop sign or a red light, and you collide with somebody else. That is an accident. This was no accident. At the hearing for the defendants pleading guilty, Ms. Mahoney, counsel for Lacey Rawlings, said that this was unexpected. Judge, you can bring into this courtroom 100 average citizens of this county and have them watch this presentation. And I'm willing to bet a paycheck that out of those 100 people, if you ask them, please give us a single word to describe what happened, not a single one of them will say this was unexpected. You had emergency personnel who are professionally trained to rescue people in dangerous situations, and it was too dangerous for them to enter these waters. You had police and paramedics on the opposite side of the creek, meaning that even in an emergency situation, nobody can cross that creek. And remember, Judge, I think that by now you have a feel for the facts, but we need to understand that the defendants were already safely on the other side of that river. They were almost home. All Daniel had to do was say to his children, we've been across a couple times, it's getting late, it's getting dark, let's just head back to Grandpa's and let's play those board games that we bought. And none of us would be standing here. Easily avoidable. Instead of Lacey Rawlings, when engaged in a discussion with Daniel about whether to proceed into those dangerous waters, if instead of saying, I don't care, the kids are having fun, maybe she should have said to Daniel, you know, we're almost home, we've been across a couple times, we're safe, I don't think it's a good idea, let's go home. That would be the reasonable response to a person in that situation. Not, I don't care, the kids are having fun. Had she done that, none of us would be standing here right now. Judge, the victim representatives that are not opposed to probation is not, as you know, unusual in these types of cases, in these domestic kind of cases. Nobody wants to see a relative go to prison. That's just natural human nature. But Grandma seems to have a different take on this. She's telling you to send a message that resonates throughout this state. That when you have care or custody of children, you need to act responsibly, whether it's for a day, a weekend, a week, or a year. And I take that to mean that there should be some punishment here. And what this is about, Judge, what your decision is about, is justice. Punishment for what happened here. For these series of very bad decisions, for reflecting on these bad decisions, discussing these bad decisions before they occurred. We're going to see some punishment for this, and we're going to see some accountability. Now, the law, 13701, their very first sentencing statute in Chapter 7, starts out by saying, if you commit a felony, you go to prison. That's what the law presumes. And we have a defendant here who has pled guilty to 10 felonies, all involving children. 3 of them, homicides. The only crime that is more serious than manslaughter is murder. There has got to be some punishment for this, Judge. The child abuse statutes impose an extra special duty upon caretakers to look out for the safety of children, to not only put them in danger, but to act to prevent them from being placed in danger. Now, we have a stipulation with Lacey that she's going to get probation. And she was not charged with the homicides. She permitted this to happen. The law says that's illegal. You permit children in your care to suffer harm, but she's pled and she's taking responsibility for it. And I believe that plea and that stipulation is appropriate. I don't think anybody in this courtroom would want to see both of these parents go to prison. I think that's a fair disposition. I think it's appropriate. That doesn't mean that we give Daniel the same treatment, because he didn't permit it to happen. He actually caused it to happen. I know the grandmother of 3 of the children mentioned the drownings, the children left in the hot car. This is worse than those kind of cases, far worse, because those kind of cases involve parents being inattentive, being distracted, and harm occurring. In this case, we have affirmative action that actually put the children into the dangerous situation. And I think that's a very important distinction. Daniel Rawlings needs to be punished. You're going to hear a lot of people say a lot of good things about him this afternoon. And there's some reference by the victim representatives that this is the first time they've placed children in dangerous situations or have been irresponsible. And I could come up with a couple of minor examples, but nothing substantial enough to refute what all these people are going to say. So I'm sure the conclusion is going to be that we have a very wonderful person here who did a very bad thing. But it should still be met with some substantive punishment. Putting him on probation may make a lot of people feel good. It may make you feel good, Judge. You've got a heart over that road. But is it justice? Is it punishment? It may be accountability, but probation for him isn't going to be any sort of challenge. He's going to pay some fines. He's going to have to report to a probation officer. He's not going to engage in any further felonious lawlessness. So that's just accountability. That's not punishment. And sometimes justice just doesn't feel good. Judge, you can't engage in this series of bad decisions, reflect on your decision, to place these children into this situation and end up killing 3 people and walk out of the courtroom a free man. That is not justice. My recommendation is that you sentence Daniel Rawlings to the minimum term of 4 years on each manslaughter count. I have no objection to you running those sentences concurrently. That is a very light sentence, a very lenient sentence, but it provides some punishment and it sends a message to people that should all have the message by now, that you don't mess around water, especially with kids. It'll provide some punishment and it'll send a message to the community. That's all I have, Judge. Thank you.
Thank you, Mr. Seuss. Before we break for our noon hour, do you know, is Miss Elledge here? Does she wish to make any statement? I was going to try to get her in.
She said that she did not.
Okay. Mark, and I don't distrust you. I just want to make sure she hasn't changed her mind since the last time she spoke with you. I think we had one person earlier that changed.
Miss Owens did not want to make a statement that the 2 children were living.
Okay. Would she like to try to do that before the lunch hour or after the lunch hour? Do you know? I'll give her.
She wasn't sure.
Okay. Let's do this. I'm going to have it after the lunch hour. I'm going to push it. Okay. So we're in just a moment, we'll stand in recess until 1:30. When we come back, we'll plan on, Miss Elledge can let me know if the one or both of the children want to give statements. We'll do that.